In this alternate history, the most ambitious civil rights electoral campaign in a century becomes the legal weapon used to silence the movement for good.
This story is fictional. It's based on real events, but everything beyond the known facts is speculation. Our goal is to explore an alternate timeline, not to rewrite history, but to imagine what might have been.
In April 2026, the Supreme Court delivered a ruling that civil rights attorneys had feared for years. The court struck down Louisiana's second black-majority congressional district, effectively gutting what remained of the Voting Rights Act's protections against racial vote dilution. Legal scholars called it the most significant rollback of voting rights since the 1965 Act was passed. Civil rights organizations called it something simpler, an attack. The NAACP responded the only way it knew how. The organization announced it would spend more on the upcoming midterm elections than in any other election in its 117-year history. The goal was direct: mobilize black voters in states where their representation had just been legally diminished, fund ground-level infrastructure in targeted districts, and use the ballot box to answer what the courts had taken away. It was the most ambitious electoral investment the organization had ever attempted. And it set in motion a chain of events that no one inside the NAACP's strategy rooms had modeled. But what if that record investment, the most public and well-funded voter mobilization effort the NAACP had ever launched, was met not with electoral success, but with a coordinated legal counteroffensive that used the campaign itself as the justification to dismantle civil rights organizations' ability to participate in elections at all? It started with a lawsuit no one took seriously at first. Within 2 weeks of the NAACP's spending announcement, a conservative legal foundation filed an emergency complaint in federal district court in Virginia, arguing that the NAACP's targeted voter mobilization, spending in specific congressional districts, constituted illegal electioneering activity for a 501c3 nonprofit. The legal theory was thin, but the court it landed in was not the court it would have landed in a decade earlier. The judge issued a temporary restraining order freezing a portion of the NAACP's mobilization funds pending a full hearing scheduled for 6 weeks out, 3 weeks after Election Day. The NAACP's legal team moved immediately to appeal. The Fourth Circuit declined to expedite. The frozen funds represented nearly 40% of the ground operation budget in 3 key states: Georgia, North Carolina, and Louisiana itself. The effect on the ground was immediate and devastating. Canvassing operations that had been scaling up for weeks lost staff overnight when payroll processing halted. Phone banking centers in Atlanta and Charlotte went dark. Voter registration drives in rural Louisiana parishes that had been building momentum simply stopped. Turnout among black voters in the targeted districts fell sharply. In 2 Georgia congressional races rated as toss-ups, Democrats lost by margins that normal turnout projections would have reversed. North Carolina's competitive Senate race, which every major forecaster had rated as a dead heat, was called for the Republican incumbent before midnight. Across the targeted states, the races the NAACP's historic investment had been designed to win went the other way. Republicans gained 7 House seats and expanded their Senate majority. The swing was not enormous in raw national terms, but in the districts where the ground operation had been gutted, it was decisive. What came next was the part that turned a political setback into a structural catastrophe. Emboldened by their midterm margins, Republican majorities in 3 states moved within 30 days of the election to pass sweeping new voter ID requirements and congressional redistricting frameworks. The new maps, drawn under the legal cover of the Supreme Court's April ruling, reduced black majority districts to near symbolic levels in all 3 states. Federal challenges were filed immediately. They faced a judicial landscape that had been reshaped over the previous 8 years. Then the IRS stepped in. A formal audit inquiry was opened into the NAACP's tax-exempt status, citing the same electioneering allegations from the original Virginia lawsuit. Not a revocation. Not yet. But it created enough legal uncertainty that major donors hesitated. Foundations that had pledged 8-figure commitments to the midterm effort quietly deferred pending resolution. The NAACP's war chest, the largest in its history, began to drain. Inside the organization, fractures that had been papered over by the shared urgency of the campaign began to widen. Moderate factions argued the record-spending strategy had been a tactical overreach that handed opponents the legal pretext they needed. Activist factions argued the moderates had never fully committed the organizational resources required for the strategy to work. Both sides were partly right. Neither had a clear answer for what came next. But the deepest damage was not institutional. It was generational. In the months following the midterms, surveys of black voters under 30 showed a sharp spike in one specific response: the belief that electoral participation was structurally futile for black Americans, that the legal system would simply rewrite the rules whenever electoral power appeared within reach, that the NAACP's unprecedented investment had not failed because of poor strategy or insufficient funds. It had failed because the system was designed to absorb it and neutralize it. Young black voters did not become angry in the way that mobilizes people. They became disengaged. And disengagement, once it sets in at a generational level, does not reverse on the next election cycle. It compounds. By the spring before the 2028 presidential primary, the NAACP's most ambitious electoral effort in its history had been transformed. Through courtrooms, legislative chambers, and IRS correspondence, into the legal and political precedent used to permanently constrain civil rights organizations from functioning as electoral actors. The 117-year-old institution that had outlasted segregation, the Klan, and a dozen attempts at legislative suppression entered the presidential election cycle without its non-profit status secure, without its donor base intact, and without the generation it had tried to reach.
In this world, history went one way. But here, we ask what could have happened. If you want more alternate timelines and government what-ifs, subscribe, comment your theory, and stay tuned. This is State of What If.